This is Ostry versus McCarthy, Ostry McCarthy, and each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes, and just let me know, please. I want to make sure you understand that we are live streaming this as well as recording it. We instruct all counsel not to use any children's names. If you want to refer to a child, refer to him as a child or as or with initials. And there are not, this is not a criminal case, so we don't have victims, but just as a reminder for future cases, we also don't want you mentioning victims' names. So we try to be very careful with that. All right, if you're ready to proceed, we're ready to listen to your arguments.
Good morning, Your Honors, and may it please the court. Attorney Nicholas Klemenko on behalf of the appellant, Paula McCarthy. I'd like to reserve 2 minutes for rebuttal.
Okay, thank you.
Your Honors, as you are aware from Ms. McCarthy's brief, the 3 central issues in contention are whether husband's mother, Rita, had donative intent to give to Ronald alone $42,000 to purchase marital property located on Sun Valley in Fair Lawn, Ohio in 2004, whether this $42,000 was traced as Ronald's separate property, and whether the court erred in imputing a wage to Paula that had no evidentiary support and was contrary to law. The issue of whether Rita had specific donative intent to allocate $42,000 for the purchase of marital property was fact intensive and should be, as the policy behind this is to prevent a parent who gifts property to both parties during a marriage and then appears years later at a divorce hearing to testify that the property was given only to benefit their biological child. The facts and circumstances and Rita's own affidavit confirm that Rita had donative intent, and her intent was to give the $42,000 to both Ronald and Paula so that they could purchase the Sun Valley property.
Counsel, one of the key things that jumped out at me was the fact that in the court's order, as well as just in the evidence that was before the court, when your client submitted her property settlements and affidavits and all the paperwork that was necessary, it's my understanding that she put that $40,000 was his separate property.
She did indicate early on in that initial affidavit that this may be separate property, but there are court cases in the appellate court, I believe in the 9th district, where when a litigant, let's say in a divorce case, doesn't request spousal support, but then later on makes the request at a pretrial or in a pretrial brief, the court says that's enough, even though the pleading is not perfected with regard to that request for spousal support. The litigant asking for spousal support, let's say in a pretrial brief, was sufficient. We did the same thing here in this case in our pretrial brief, and we did not acquiesce to this being separate property. We in fact said that it was an issue in dispute, and we noted—
Okay, counsel, let me just interrupt you though in regard to that, because I'm a little confused. My understanding is she presented that evidence as to what property was hers and what was his under penalty of law answering it. I mean, this wasn't just changing your mind whether you need spousal support. This was supposed to be something that was submitted to the court to give the court an accurate, overview, or not just an overview, accurate recitation of what the what property belonged to who and what the claims were of that property. So I guess I don't see how that's the same as just changing your mind on spousal support.
Well, I think, she indicated during the testimony that this was something that she had copied off of her husband's affidavit, and that she wasn't entirely certain when she was filling it out. I'm not commenting on that attorney's legal advice at this time. We didn't wish to bring that up in some sort of legal malpractice claim. However, it was stated on the record that she was copying her husband's affidavit, that she was not entirely certain as to this, and that it wasn't a surprise on the day of trial when we showed up at court and said that, we're saying that this marital home is entirely marital. In fact, it was mentioned at previous pretrials. It was mentioned in our pretrial statement. So it was not a surprise at court on the day of trial.
Thank you.
Thank you, Your Honor. The facts and circumstances and Rita's own affidavit confirmed that Rita had donative intent to give the property to both parties. The court relied heavily on an affidavit of Rita's created during the pendency of the divorce case, created by Ronald's sister, not created at the time that the so-called pre-inheritance was made in 2004. What we know is that Rita intentionally transferred the $42,000 during the marriage to purchase Sun Valley, a marital property. 1 month after the divorce was filed, Rita testified that she was asked to make the affidavit by her son, Ronald. Rita obfuscated. She first testified that this was a pre-inheritance to Ronald in 2004. However, then she characterized the $42,000 as a gift during her testimony. There were no other documents provided to present indirect or direct evidence of Rita's intent. And Rita even testified that her affidavit was the sole intent behind transferring the $42,000 and that no other documents existed between 2004 and 2018 evidencing her intent. And so if that is the case, and we look at her affidavit, she said in a quote, "My son, Ronald Ostry, together with his wife, Paula Ostry, used this pre-inheritance amount towards their purchase of a new home located at 414 Sun Valley, that they could not have afforded this home without my bequest. Therefore, but for both parties receiving this gift, they could not have purchased this marital home." That was the intent of the donator. There's no check, there's no will, there's no bank transfer indicating that this money went directly to Ronald. If all we have is that affidavit, I think that is sufficient. And one of the reasons why I think that shows donative intent is because I cited a case, Sharp versus Sharp, where husband quitclaimed his interest in real property to his wife, which had some separate property interest in the home. He later came to court and he argued that he only did this to evade a lien on taxes and that he might die before his wife. The court concluded that the transfer of property done with the purpose of avoiding creditors constitutes clear and convincing evidence of donative intent to convert the property to marital property. Likewise, Rita's intent to give the money to both Ronald and Paula to purchase a marital home that they both could not afford without this money evidences donative intent to give this money to both parties as indicated in the same policy in Sharp. And the Sharp case goes on about the policy behind this, this ruling and finding clear and convincing evidence. And we think that that case fits our argument here.
Well, let me ask you this. I don't know, maybe I'm incorrect, but I was thinking nobody's really disputing there was donative intent. It was just whether it's donative intent to give to husband as his separate property or to give to the son and the wife.
That's correct. And I mean, obviously she transferred this money, so it's automatically, there's some donative intent involved in that. Further, there was nothing done to trace the $42,000 as Ronald's separate property. Ronald testified that the original loan for Sun Valley was through Wells Fargo, but did not present a mortgage statement from Wells Fargo or a response to a subpoena issued to Wells Fargo that they no longer held these records. There's no deed showing a down payment as to how much was allocated to Sun Valley. In total, no documentation was produced to trace the issuance, receipt, or use of the $42,000 Ronald claimed as separate property. There's a case that I cited, Peck versus Peck. They held that the court did not err in awarding husband a $10,000 separate property claim because he presented no documentation or other evidence to the trial court to sufficiently trace his allegedly separate property. If a litigant is going to claim that something is separate property, then they have the burden of proof to show by a preponderance of the evidence that this is separate property and tracing it. And we hold that this was not done. Therefore, even if the court found that donative intent was somehow found in that affidavit, we'd say that the property wasn't sufficiently traced.
Mr. Clemenco,
Yes.
during the course of the trial, did your client dispute that full amount, whether it was $40,000 or $42,000, went toward a down payment for the house? Was that an issue?
No, it was not in dispute, Your Honor.
Okay. Thank you.
You're welcome. The last issue is we argue that the court erred when it conducted its own appraisal of Paula's future earning, contrary to any evidence, and the trial court erred when it ordered spousal support against the manifest weight of the evidence in light of the factors pursuant to Ohio Revised Code 3105-18 and the 14 factors therein. I'm going to defer to Ms. McCarthy's brief because we did an extensive argument regarding the 14-factor evaluation, which I think is sufficient for that argument. However, I do want to touch on the imputation of Paula's income that the court engaged in. Unlike the child support statute, the spousal support statute does not direct the court to impute income. And this was ruled in the 9th District Court case of Collins versus Collins. Paula's argument is that the trial court can consider potential income of the parties. However, a party's potential earning ability should be appraised by a qualified expert. Where there is no expert evidence, the court must rely on the testimony of the parties and not sua sponte conduct their own appraisal concerning a party's income.
But counsel, wasn't there evidence as to her earning ability? Why was an expert necessary here when she testified to how much money she earned babysitting in her home?
There was testimony that Paula was testifying that she was only babysitting one child at that time and that she was earning a certain amount of money. I think it was roughly $7,000 a year, which we went ahead and incorporated into our fin plan calculation. Instead of evaluating Paula's income based on the 14 factors, the court did their own imputation of her income. Essentially, that's just what they did. They added up some previous earnings from Paula and just imputed her income based on that. And so we're saying that that was an error of law.
I guess what I'm trying to say, I'm getting confused because I don't know if there's actual evidence of earnings, isn't that a little different than somebody that comes in with no earnings and then you say, well, I think you can earn such and such amount? The court had actual earnings to look at, right? You're just disputing that the court didn't accurately look at these earnings.
They had some previous earnings, and our argument is that they were not, the court in a spousal support case is not to impute income pursuant to the statute. They're supposed to determine the party's relative earning ability.
Okay.
And in fact, what the court did is they did a de facto imputation of income by saying, this was a previous amount, we're going to impute her income. And so what I'm
Counsel,
saying,
I need to stop you until you're in your rebuttal time now. If you would like to save that or go on, it's up to you.
I'm going to say that. Thank you, Your Honor.
Thank you. Okay. You have 15 minutes, counsel.
Thank you, Your Honor. Attorney Brennan Coors for Ron Ostry. Your Honors, I believe my briefs kind of stands on its own in reference to the issues that are at hand with the court. Manifest weight argument in and of itself relieves the court in reference to the fact that the original trier of fact to determine what is appropriate in reference to the weight of the evidence that's given to each one of those factors that are given to the court to make its determinations. In this aspect, in dealing with assignments 1 and 2, which are kind of one and the same because they deal with the separate property issue, we went into that quite extensively. We had several other hearings, pre-trials in reference to discussing this issue. This is an issue that was in both parties' affidavits indicated on page 5 in the separate property section. My client put down $42,000 provided to him by his mother as a pre-inheritance / gift. In reference to the Miss Ostry, she put it down as $40,000. When we had testimony that was given, my client testified to $42,000 given to him, which was actually $2,000 more given to him than his siblings, of which he had 2. The wife testified that she just blindly copied my client's property affidavit upon being served. And when I questioned her about that issue, she indicated, yes, I copied it. Well, and I said, well, why did you then go from 42 to 40,000? Well, because it was $40,000. And then you indicated, and she indicated it came from my client's mother and went to my client for purposes of purchasing the home. Ms. Rita Ostry testified to the fact that she sold a home and gave the proceeds to each of her children. Another person that testified was my client's brother, Edward Ostry, who also testified that he received $40,000 from his mother for purposes of purchasing a home, to which he hadn't done at that time. So he went ahead and put the money in the bank. In addition to that, Mrs. Ostry testified that she had cut the amount of money down to, I believe it was just shy of $10,000 per check that she wrote out in order to try to avoid an inheritance tax, so to speak, although she didn't do this over a period of years. She did it in a short period of time. But no one asked for the inheritance tax information in reference to our case. The court was very clear in reference to indicating to opposing counsel that, especially in the decision, that this was deemed to be separate property. The donative intent was to give it to my client for purposes of purchasing the home. Otherwise, they couldn't have done it. So,
Counsel, what can we take from the fact that you have brother testifying, yes, mom gave me $40,000 as well, but brother wasn't married at the time, right?
That is correct. He was not.
So there wasn't any evidence there that we could look at and say, well, she did this consistently with everyone.
Well, in reference to that, she gave it consistently to each one of the children.
Right.
Her children. And she testified that she gave it to each one of her children, and that was her testimony.
Well, again, I don't think the issue is donative intent or, any of that. It's a matter whether she gave the $40,000 or $42,000 to him personally, separately, or to husband and wife. And there's no testimony from the sister, right?
No, there is no testimony from the sister.
And she was married at the time she received her gift.
I believe she was. Yes.
Thank you.
So, and in reference to that, Your Honor, that's where we are with the tracing issue itself. That was not brought up during the pendency of the trial. I did my best to bring in the testimony that I could find in order to show the donor, not only the donor of the tent, but exactly what had occurred in reference to those monies. And that was the testimony of both the parties, Miss Ostry, Miss Rita Ostry, and Mr. Edward, to and including my own client, and then Paula Ostry herself, who also indicated the fact it was husband's separate property in her own affidavit, to which at the time she had an attorney helping her out, and not an attorney who'd been around for 5 minutes either, one who's been around for a long period of time. So now moving on to spousal support. This was another lengthy period of time in the discussion, because I had requested 4 years worth of bank statements and received 3 months of such, 2 different accounts. We went through each and every transaction because there were several issues that were going on with whether or not she could work or not work because of her knee surgery, needing knee surgery, her need for, I can't get my knee surgery because my A1C is off, and so forth. My client also had knee surgery during the period of time and works a factory job. Had nobody there at home to help him out. And yet he rehabbed himself and got back to work in order to pay the spousal support that was originally ordered in the temporary orders. To which we found out during the trial that the 3 months that I was given of the bank statements, she had been earning money from babysitting in her home. When she testified with that attorney that she had at the time, that she had no income whatsoever. So the court found the fact, and I believe the court found in that aspect that wife's testimony to be, for lack of a better term, off-skewed. I believe her veracity was of concern at that point. And then when you look at those 3 months of bringing in approximately $6,000 during that period of time of untaxed monies, to which she had admitted to each one of the individuals that she received money from for babysitting, and one of the children even being a 2-year-old, a very mobile two-year-old in that, which, by the way, is the same type of occupation that she had all the way through the marriage, was having babysitting in the home, up to 5 to 6 children at a time. So I actually asked the court to impute her closer to $24,000 because of the $6,000 that I had during that period of time that we went through. The fact that the court went through all the factors within the statute, did quite an exhaustive analysis of the statute. I mean, the entry itself, the decree itself, is approximately 90-some pages. So I believe the court found appropriately to impute her to a reasonable wage of minimum wage. So I'd ask the court at this time to, and in reference to counsel's argument about an occupational study, there was never one asked for during the entire time of the case. They did not ask for one during the trial. They didn't ask for one during discovery. There was just not one, period. This is basically their chance to try and take a second bite at the apple that was never asked for. So, and then at that point, once we went through all of our evidence in reference to my client and his wife's earning potential, I believe it would be their burden to prove at that point that she could or could not work, and or bring in an occupational investigation, which was never done. So we would ask the court to uphold the trial court's decision in this matter.
Thank you, counsel. Any questions from the panel?
Thank you. I have a question, counsel. So you mentioned that the plaintiff's mother testified that it was the $42,000 was for the sole benefit of her son. But is it, and that was in her affidavit, though, indicated that the plaintiff and the defendant required that money to purchase the Sun Valley home during their marriage, which of course was a property interest in which both parties benefited from. So my question is, isn't it true that the cross-examination plaintiff's mother testified that the transfer of the money was intended to benefit both of the parties during their marriage, and that they could not have purchased that marital home without that money?
I can't disagree with the fact that she indicated one thing in her affidavit. She also indicated during her testimony, both on direct and redirect, that it was meant for her son and given to the son for purposes of purchasing the home.
Thank you.
Okay, thank you very much for your presentation. And the appellant will have 2 minutes remaining.
Thank you, Your Honor. I think the affidavit obviously was intended to show that this property was in fact separate property, but it just didn't meet its burden to do that. And I think shows the weakness in husband's argument that this was separate property. The way it was written and drafted, at the least, it's ambiguous as to whether or not this was clearly supposed to be given to Ronald alone and not Paula. And then just on the face of it, I mean, when you read it, or when I read it, I see that the donative intent, just like a deed, I mean, you don't need to look much more outside the four corners of a deed when you say, like in that Sharp case, husband's going to quit claim a deed to wife. Well, we know that that's the donative intent. And that affidavit is like a deed showing that Rita was quit claiming her interest of $42,000 to both Ronald and Paula. And we know that's the fact because they were married at the time. The brother who testified and received the same amount of money wasn't married at the time. So we don't have any concerns about that. But then Rita testified that she gave, once that brother did get married, she testified that she gave the husband and wife gifts. So if we use that circumstantial evidence and attach that to the four corners of that document, we know that her donative intent was to give both parties that money. The policy implications of this trial court's ruling would prejudice all future litigants, as now a spouse can come to court with a self-serving affidavit or testimony, similar to a case that I cited, like Sharp or Strasburg, and defeat the marital interest in property that the other spouse rightfully maintains in this interest. That's Paula. We're asking this court to return a decision that awards Paula her interest in that home, which is rightfully hers. Thank you.
Thank you, counsel. Thank you both for your presentations to the court and the arguments that you made. It was very helpful. We will take the matter under advisement and we will send you a written copy of the opinion. I say the clerk of courts will send it to you. And we also release on our website, the Supreme Court website, so you can look at it electronically.